You are watching the LemonAID podcast with Amar Law Group. Join us as we unlock the secrets and expert tips you need to know now.
Hi, everybody. Welcome to the LemonAID podcast. I'm Matt Sky. With us is Shalev Amar, managing partner and founder of Amar Law Group. Shalev brings a wealth of experience in consumer protection law, specializing in lemon law and breach of warranty cases. Shalev, thanks so much for joining us.
You're welcome. Glad to be here.
So let's just jump right into it. Can you share with us your journey and how you became an expert in lemon law?
Well, I wasn't originally planning on going into this area of law. Originally, when I went to law school, I wanted to be kind of like the crusading prosecutor. I grew up watching Law and Order. And in my mind, what I wanted to do is help protect society, take serious criminals off the street, murder, rape, things like that. And when I did a couple of internships, I saw that that's not what it was really like. A lot of what, at least starting out as a prosecutor, entailed was prosecuting low-level crimes, drug crimes, and I just realized that it wasn't really for me. I believe that addiction is a medical issue, oftentimes for people who have a genetic predisposition for addiction or people who are severely traumatized or self-medicating. And I just don't believe that using the criminal justice system to penalize people for addiction is the right way to go. So last minute, I basically just decided to completely shift things over to go to civil practice. The other reason is, even though I could have gone into defense work, it was actually the opposite. In defense work, you oftentimes are defending the rapists and murderers, and I couldn't do that either. So I decided to go the civil route and basically just got the first legal job that I could. I knew absolutely nothing about lemon law. We learned very little about warranty law in general in law school. Lemon law is basically just a colloquial term for warranty enforcement statutes that enforce manufacturers' warranties, mainly on motor vehicles. I knew basically nothing about this area of law, so I had to completely learn it from scratch. I started at a large national firm that had satellite offices throughout the country. And the great thing about that, the pay was terrible, but what was really great about it was I got a ton of experience because they just threw me into the fire, into depositions, trials, motion practice, oral arguments. And so I'd say my first 2 years of practice working at this large national firm, I got more experience than many attorneys do in 5 to 10 years when they're working at a more stratified firm where junior attorneys don't get to handle anything large. It was the opposite for me. I was actually very overworked, but I got a ton of experience. And just the way they practiced law did not sit right with me because the firm, they put themselves first rather than their clients first as far as getting paid. They didn't care what their clients got as long as they got paid their attorney's fees. There were even cases where they would get paid more in fees than what the clients ended up getting in compensation. That never sat right with me. And so when my original partner and I started our own firm, it's a previous firm to my current firm, we decided that we're going to do things differently and put the clients first. And the way I see it is, even in an individual case where you might waive a part of your fee, we actually have a fair fee guarantee where we never get paid more than our clients for out-of-court representation. 95% of our cases are ultimately resolved out of court. The way I see it is, if you do right by your clients, even if you lose in a particular case as far as how much fees you can get, long-term, it works to your benefit as far as positive reviews, word of mouth, referrals, and you'll get it back tenfold. So the way we do things is much different than the way most of our competitors do things. We put our clients first.
I think it's so important. As we delve into lemon law, what qualifies a vehicle as a lemon?
Well, it's a bit complicated because there's various factors that go into that. I would say, internally speaking, the way we look at it is we believe that if a vehicle is repaired at least 3 or more times for the same substantial defect or condition, that would qualify as a lemon. The other way that the vehicle could qualify as a lemon is if it's in the repair shop too long. And we believe if a vehicle is in the repair shop at least 25 days or more, then that could qualify as a lemon. But the standards do kind of vary by state. As far as we're concerned, though, what the lemon law talks about, all lemon laws, is reasonableness. And so in our view, if you have a brand new vehicle and it's repaired under warranty 3 or more times for the exact same substantial issue, that's unreasonable. Therefore, at a certain point, the law says enough is enough. To me, 3 or more repairs for a substantial issue, that's just unreasonable, and that would qualify. And the same goes for too much time in the repair shop. We believe that 25 or more days in the repair shop is unreasonable.
So let's say I'm a consumer and I suspect I have a lemon. What's the process I should follow?
The most important thing when you're dealing with a defective lemon vehicle is to make sure that you have proper documentation. That means every time that you get a repair, you must get a copy, it's called a work order or a repair order, after the repair is completed. And you also need to make sure that it has correct information. So that it has all of your complaints listed, what diagnosis was done, and then what repairs were done. And also it needs to correctly show the vehicle's mileage and whether the repairs were covered under warranty or not, and the time that the vehicle was out of service in the repair shop for the warranty repairs. Documentation is extremely important because you just don't want to get caught in a he said, or he said, she said situation, because the consumer bringing the claim has the burden of proof. That means if there's 2 different stories about what happened, the tie goes to the other side. So you got to get documentation because those are business records, which are basically an admission of the repairs that were done and that they were covered under warranty. So always make sure to get repair records. Don't just rely on memory or on the fact that you had a phone call. Get repair records. Secondly, if you do see that you've been in the repair shop too many times, a common mistake that consumers make, and look, they're acting in good faith, they just want to resolve their defective vehicle issues, is that they will reach out to the manufacturer. And one of the worst things you can do is complain that you have a lemon vehicle, or even worse, threaten lemon law or threaten to hire an attorney, because what that does is that will cause the company to basically flag your vehicle in their system as a potential lemon law claim. And that can lead to all kinds of nonsense, like you continuing to have repair issues and then they blame you for the repair problem, or they say that they're just doing the repair as goodwill. Goodwill basically means like, oh, we're just doing it out of the goodness of our hearts. This is not a warranty issue, because for the lemon law to apply, the repairs have to be done under the manufacturer's warranty. So if it's goodwill, or the dealer might even call it internal, and we go after manufacturers, by the way, not dealers under the lemon law. But the dealerships, although they're independent entities, they are business partners, or at least affiliates of the vehicle's manufacturer. They just do repairs on the manufacturer's behalf, and they try and protect their business partner or associate. So it's counterintuitive, but if you suspect you have a lemon vehicle, the last place that you should go is to the manufacturer. What you need to do is to reach out to an attorney to get a consultation and an evaluation of your potential case to find out what your rights and options are. And you should always do that before reaching out to the manufacturer. The less you say, the better. It's kind of like what you see in the movies and TV shows. Anything you say can and will be used against you. That's the other thing. They will oftentimes twist around what you tell them to try and blame you for the problems, to try and argue buyer's remorse, or to try and argue that you misused the vehicle. And you might unwittingly say something that could damage your case. That's the other reason why you should confer with an attorney before you even think of reaching out to the vehicle's manufacturer.
So you laid out for us some common misconceptions. Don't reach out to the manufacturer. Make sure you document. How does having an attorney help consumers navigate lemon law claims?
Well, the way an attorney helps is they are legally trained in this area of law. They understand the rules of evidence. They understand the rules of procedure. So they can protect you from numerous pitfalls that you can fall into. Attorneys can also advise you about what's the proper way to deal with the repairing dealership. How do you request repairs in a way where they don't give you the runaround? How do you get all of the records that you need, especially repair records, if any are missing? Basically, what to say and what not to say. Because attorneys, they have a fiduciary duty to their clients. So what does that mean? Fiduciary duty means that they have a duty to act in your best interest. The companies, they have zero duty to you. I mean, their duty is basically to control costs and protect their profits. So as far as the company is concerned, it doesn't mean they don't ever do right by consumers, but it's just the incentive structure is the opposite. The company is looking out for itself. It's not looking out for you. So you got to understand that an attorney advising you is advising you what's in your best interest. They're trying to maximize your recovery and get you out of the problem. The company, on the other hand, they have a totally different incentive. The company's incentive, like I said, is to control their costs and to spend as little money as possible on lemon law claims.
So to that point, what are key protections and rights that lemon laws provide consumers?
Well, lemon laws, basically, like I said before, they are warranty enforcement statutes. So the lemon law is there to say enough is enough when a vehicle has been repaired too many times or has been in the repair shop for too long. And so what the lemon law does is it gives teeth to the warranty. Because look, most warranties, they are what are called limited warranties that are for repair or replacement of defects in materials and workmanship. So the argument that a lot of companies make is, okay, as long as we're doing repairs, we're complying by the warranty. But that's a disingenuous argument. And the reason is because at a certain point, it's just unreasonable if, say, you're repairing the same substantial problem 3, 4, 5, 6 times. I mean, how many times is a consumer supposed to turn his or her life upside down, miss time off work, miss time off school, miss time off leisure time, basically anything else they would rather do other than be in a repair shop, hanging out at a dealership without their car, having to Uber then to work, Uber to school, or even if they get a loaner vehicle or a rental, oftentimes it's not the same vehicle that they're paying for. It's a much lower caliber vehicle. And it's just extremely frustrating, extremely inconvenient. And just imagine you buy something brand new and let's say that the brakes are causing a vibration in the vehicle and they're squealing too. And, it's only got a couple of thousand miles. Every time you stop at a stop sign, every time you stop at a stoplight, you're dealing with frustration, aggravation. You're concerned about the reliability of your vehicle. You're concerned about whether it'll get you from A to B without getting you killed or hurt. And that's not fair when you're paying a brand new high vehicle price. And so what the lemon law does, I know I keep saying this, but what it basically does is say enough is enough at a certain point. And it says, at that point, you should either be able to get your vehicle bought back. It's called the lemon law buyback, where they refund your money, the payments made. They'll pay off any outstanding loan balance if you have a loan, minus mileage. Now, that varies by state as far as mileage. It's called a usage offset or a usage fee or a mileage fee. And in some states, it's based on the first reported defect that the vehicle ends up being reacquired for. In other states, it's based on total miles. Some states have a formula for figuring out cents per mile. Some states do not. So there's some variation by state, but every state has a usage fee. It's just how it's determined is slightly different depending on the state, or sometimes it's a major difference. Obviously, the first defect can be low miles compared to the total miles that you've driven. The other option under state lemon laws is what's called a new vehicle replacement. The way that works is it's typically sticker price to sticker price. It's got to be by the same manufacturer. And then so you replace the defective vehicle with a new, hopefully non-defective vehicle. And if you have a loan, it's what's called a swap or a substitution of collateral, where you keep the same loan, but you swap it out for the new vehicle. Now, if the replacement vehicle is more expensive, you typically will have to pay that difference, but that price difference, the sticker price to sticker price. But most states do not require a usage fee for a replacement. That's the big positive to a replacement. A couple of states do. The biggest negative, though, to a replacement is sometimes it could take a very long time to get a replacement vehicle, especially if it's not in the inventory, to get, the color and options that you want. We're just getting over a huge microchip shortage, which has caused a lot of production delays in virtually every motor vehicle company. The third option is typically not in any state lemon law, but it's an option under the federal lemon law, which is called the Magnus-Amas Warranty Act. And typically, the Magnus-Amas Warranty Act also applies when the state lemon law applies. Well, we can go into more detail about that later. But the Magnus-Amas Warranty Act, it's pretty vague about what you're able to get. And so typically it just looks to state warranty law, what's called state common law, which is basically judicial opinions about warranty, also state provisions of the UCC, which means the Uniform Commercial Code. But the main type of remedy under the federal lemon law, the Magnus-Amas Warranty Act, is what's called diminution in value damages. It just basically means you didn't get what you paid for, so you should get a partial refund, but you keep the vehicle.
Right. So, Shalev, as we wrap up, can you share a success story where you helped a client resolve their lemon law case?
Well, we've actually had thousands of those. I can talk about a more recent one. We had a Tesla client who was just dealing with major paint issues. There were actual swirl marks in the paint, very defective paint. The vehicle basically had to be repainted from scratch. And because of that, it was in the shop for a long period of time, and also it kept having to go back for the paint. And so I'm going off memory here, but I believe it was repaired, that is, maybe 7 or 8 times for the paint defects. And in the repair shop, maybe 40 plus days. And so it took some haggling, but eventually Tesla did do right by its customer and bought the vehicle back. One of the arguments or contentions that we make to manufacturers is to not have a scarcity mindset about resolving these cases. Because like I told you before, oftentimes they look at lemon law issues, vehicle lemons, as being a major cost for them. And it is admittedly a cost, but they can look at it a different way. They think oftentimes that it's buyer's remorse or people are too neurotic or too demanding, but oftentimes people do have valid claims. And the better way to look at it, and it's one of the things, like I said, that we do argue on our client's behalf, is, hey, look, take care of your customer. Make your customer happy, and you will keep them as a customer. Not just that, you'll get positive word of mouth, because then they'll tell their family and friends and acquaintances, you know what, I had a problem with my vehicle. It was a lemon, but the company accepted responsibility and they took care of me. So I think one of their underlying concerns is that, you know, if we're too pliant with lemon law claims, then more people will come after us. And maybe in the margins that's true, but I think that's more than made up for by the fact that if consumers know that you take care of them, that they will buy more of their product, you'll have positive word of mouth, and the extra sales that you'll have will more than make up for what you have to pay out in lemon law claims. So, you know, we do try and persuade the companies to look at these claims that way. And oftentimes we're successful with that, but you know, corporate culture is different for every company.
I think that's a fantastic point to wrap up on. Well, that's been our show. Thanks again for listening to the LemonAID podcast. The Amar Law Group legal team operates throughout the West and Southwest. Check them out on social media and the links below. If you're in the Arizona area, find them on ArizonaLemonLawAdvocates.com or enter your state and LemonLawAdvocates.com. Shalev, thanks so much for your time.
Thanks for having me.
Thanks for watching. Be sure to hit that like and subscribe button and comment below.